Well, good afternoon. How are you today? Well, the Thomas Jefferson weather report goes like this. It's in the 70s somewhere, but feels comfortable, even kind of cool. And it's overcast, looks like rain, but hasn't rained, but may rain. And early today, Holly and I took a break, sort of a reward for working hard yesterday, to nearby Waterford, a great Quaker community. And I owned a place there once, and I just loved that little town. But you can't go back. You know, I look at it and I think, well, the people are different, and the place has changed, and the traffic has changed. But it's really just a charming community. So after some work, I saw what was going on today. In the D.C. trial, we have Trump trying to avoid that in some way or other. And I think his legal actions are more concerned about how he can influence his base. But at some point, a base of 30 or whatever number of points above that in battleground states cannot win an election, which is his plan. But there have been notions among people in the past who have sought to be fascists or dictators or autocrats, any of these categories which strikes out at the individual's right to vote for whom they want and seeks to impose upon people a government that suits those who seek to impose it. And so it's been said by some people, if you give me 2 or 3 people in an area, I can turn that around. I can turn that active minority into a force that allows me to overcome the democratic principles. Okay, so that said, is that what Trump is doing when he goes into court and asks Judge Chutkan, hey, I think I'm immune. I'm immune because I was president. Now, there's a whole bunch of history involved with this, and it's kind of ironic, the people who have said that a person, when not any longer president, could be prosecuted. And we can remember who they are, but it doesn't matter because it's the law that counts. The law says this. Vice President Agnew is the closest case to describing how the law works, even though he was a vice president. He was involved in bribery in Maryland. And the thing that was interesting was when he was prosecuted, he said, you couldn't prosecute a vice president unless you first impeached him. And that clarified the law, because what the opinions were included the fact that impeachment is for removal from office. It's not a criminal prosecution. A criminal prosecution is for crimes. Now, I believe that allows you to prosecute a sitting president. And there's a lot of people who agree with me who are special counsel in various investigations, including Starr, who comes from the Republican side of the aisle. And so the issue, therefore, that he's raising is frivolous. There's another part of this that's important. And I heard somebody describing this as an interlocutory appeal, like that's an appropriate thing to do. But to say something's an interlocutory appeal is to say that you're making an appeal before there's a final judgment in the case. And normally and ordinarily, this frivolous issue that Trump is bringing up would merge into the final judgment and only be challenged for the first time on the appeal from his conviction. If there was no conviction, there'd be no appeal. Now, that's not exactly the case. Sometimes prosecutors can appeal when the defendant prevails in the lower court in a criminal case. Now, some say, okay, so the circuit court, after Judge Chutkan deep sixes this application by Trump to give him immunity and dismiss all the cases because he was president, well, when she does that, then he may go to the circuit court, and the circuit court will likely say something like I've said, although in many more pages, and it'll amount to saying, what are you talking about? You don't get a chance to do this. And I guess Trump's thinking is, well, then I'll petition the Supreme Court for certiorari, and then they will give me an opportunity. But I'm not so sure they will, because the law is so clear in two parts. One, the first part, is that, I'm sorry, but because you were president, you don't get immunity from these things. And two, since it's interlocutory, you're not raising it after a final judgment, we deny it for that reason. So, the lawyers must know this. They must have told them this. So they're filing a frivolous action. Well, they tried to cook up a theory that is different and separate. And on some level, they know that dog don't hunt. So that's an example of how the court system is being abused. Now, my partner, Jim Campbell, and I, we've considered what kind of motions do you make? And it has to pass the laugh test, but more than that, it has to reflect well on you as an advocate. So we call it the momentum of litigation. If we make a motion based on good facts and good law, even if we lose, if it was legitimate, if it was non-frivolous, if it was substantial, then you make that argument. And the court is in a position to say, well, I saw what you were trying to do, but I disagree. And you've also preserved an objection, should you have an appeal, to revisit that issue later. But this is not that kind of issue for Trump. What Trump is trying to do is he's doing in the courtroom what he also does out of the courtroom, which is to make arguments that are bullshit and hopes that the nation will say, yeah, why can't he do that? Why isn't he immune? Because he's not king, for Christ's sake. He is a failed casino operator and crooked land dealer who tricked America into making him president and will rue the day for 10 or 20 or 30 years, I'm sure, with all the damage and terrible circumstances he's created. But enough of that. What else is Trump doing? Well, there was talk about Trump himself becoming the speaker, and that would solve the problem. Very unlikely, but let's run the traps on that one. If you are in the Congress and you are indicted, you may not run for the speakership. So how in the world could Trump be the speaker when he's already got 4 separate indictments, any one of which would be enough to prevent him from running for speaker? So he was going to go to the Hill, but he's not doing that. But what he is doing is he's supporting No Jacket Jordan to be the speaker. Well, that's really something. We have a guy with felonies that can't be for 60, 90 days, 45 days, as he suggested at one point, that he be speaker. And he can't do that. And he's no longer going to the Hill, because it'll probably look embarrassing. Let the mountain come to Muhammad. And so he instead has sanctified No Jacket Jordan. And they're off to the races. Now, what does that really mean? Well, there are several people testing the waters, if you will. And certainly leading the pack is Jordan and Scalise. And there are a couple of other minor skirmishes. And what they're doing is they're trying to meet with different elements of the Republican conference in the House and persuade them that they are the one. I could have been a contender, that's me. Well, can you imagine anything more ridiculous than either of those guys trying to put together coalitions when their mark of the devil is that they can't agree with anybody who doesn't already agree with them. So I don't see how they could put it together. But that's what they're about. That's what they're doing. And it's kind of funny because it was Jordan, Scalise, and Hearn, I think his name is, were invited to appear on Fox together on Monday evening. And apparently, first there was an agreement, and then there wasn't. Now, why would that happen? Well, fear of looking bad, but it seems to me that if you're bargaining crosswise in different ways with different components of the Republican conference, you may want to say something slightly different with one group as compared to another. That could be part of it. And also, these guys, they really have reputations for playing fast and loose with the facts. So there's that. Anyhow, they've since decided not to do the show, so they're not going to be on there. It's pretty amazing what we're dealing with here when you consider who these people are. Now, the minority leader, the head of the Democratic group in the House, Jeffries, who is a measured and insightful and strong leader who I think does return to first principles in terms of wanting to be effective because, like me and you, he believes that it matters. Content matters, policy matters, action matters. So he said in an editorial in the Washington Post today that how about a coalition government? That is, we figure out a way that we can actually get the business of the Congress done. Now, I see that happening, but the only person I see taking that position is Jeffries. And there's the rub, to borrow from Shakespeare, because the Republicans won't agree to that. But it is the one thing that might save some of their members in a general election. And from that standpoint, it's a dangerous position for the Democrats to take. But I've been on the Hill when we've taken positions, and we took the best and clearest position. And one of the arguments was, well, what if the Republicans did that? And my view, and the view of others, was, well, it would be the right thing, and if we won, we won. And if we lost, well, it was at least fair. Now, that's a lot to swallow, but the reason that in my several instances when this occurred, the reason that the Democrats agreed to it is because they believed, rightly so, that the Republicans would never embrace this, like there's some trick there, besides the fact that one side or the other could win or lose. They just wouldn't touch it. There's been a rumor that McCarthy would resign once the speakership thing is sorted out. Well, you know, good riddance to bad rubbish. I don't know if you go to K Street or try to run for governor somewhere, you know, but that's not my concern, because he folded to the MAGA extremists. And if that's the pitch the Republicans take, I have my doubts that we could figure out how to get around the spending bills in the 45-day period that they set. I think that's going to be ridiculous. Sort of one I wanted to talk about the other day, it crossed my mind, and then I didn't think about it, and I almost missed it right now, was Ruth Marcus, brilliant woman, writes for the Post, believes she's on the editorial board, and she wrote an op-ed basically saying, are we being too harsh in the civil case in New York, punishing Trump too terribly? Well, you and I probably say, no, absolutely not. The punishment that you might consider extreme is in proportion to the outrages that this guy has wrought. It's just not reasonable to give him slack when he deserves none. Gives no reason by excuse, by admission, by explanation for basically lying to banks and the IRS and all sorts of other people. So Ruth is, she's a powerhouse, don't get me wrong, but her empathy and balance in this case, I most respectfully say, is misplaced. We give no quarter to people who've tried to overthrow our government. We give no quarter to people that show no admission, no contrition, no avenue back from their bad acts. And we have to know our own mind. And in this day and age in the public arena, that means we have to know what our standards are. And if our standards are to tolerate criminal behavior that would overthrow our government, then we shouldn't be surprised when our government fails. We shouldn't be surprised when people suffer and punish and lose freedom because we have, by our passivity, by our lack of passion, by our failure to act, made it possible. So, those are my thinkings on Friday, and I hope you're having a good day. And so I say goodbye to you from my cathedral of trees, the only reliable thing as compared to public officials. All the best. Bye-bye.